Well, a very good morning and welcome to Compulsory Arbitration and COVID-19 Rent Arrears. This is the latest in a series of property law webinars given by St Philip's barristers. My name is Christopher Buckingham. I've been at St Philip's in Birmingham for all of a month and a half, before which I spent 9 years or so in Leeds doing property litigation and a mix of other things as well. Today's seminar is going to be in 5 parts, starting with an overview, then giving some context to what is at the very heart of the seminar, the bill itself, followed by some conclusions, and then, if time permits, we will have some questions at the end. The 9th of November 2021 was a very exciting day indeed. There was not only the first reading of the commercial rent coronavirus bill, but also publication of the even snappier titled Code of Practice for Commercial Property Relationships following the COVID-19 pandemic. The bill itself is expected to become law on the 25th of March this year. It's been through the House of Commons and it's currently proceeding through the House of Lords. And in a nutshell, it provides landlords and tenants of business tenancies with a binding arbitration structure and a means of suspending the normal methods of pursuing or enforcing debts through the courts. To give some context to the bill, there were, and indeed are, some previous measures introduced to afford tenants a degree of protection, but the overall structure was rather fragmented. Those listening will be well aware of Section 82 of the Coronavirus Act 2020, which prevented forfeiture for non-payment of rent during the relevant period, which has been extended time and again, but is due to expire in March. Restrictions on CRA, and also a bar on presenting winding up petitions in respect of excluded debts, i.e. rent, during the relevant period, which again ends next month. I said the measures were fragmented. There was no restriction in respect of bankruptcy. So where a tenant of a business tenancy was an individual, he or she could have been made bankrupt on the basis of rent arrears. And secondly, attempts to run substantive defences by clever and imaginative lawyers didn't tend to get very far. And I've cited one case there, but there are a series of cases which usually ended up in summary judgment applications. A bit more context to the bill. There are quite significant rent arrears in the market already. As at March 21, it was about 6.5 billion. And by this March, it's expected to rise to around 9 billion, forgive me. That's a Treasury figure, so it must be true. The causes, of course, are the pandemic itself and the various closures that were organised or imposed, I should say, by the government on various sectors in the economy for lengthy periods of time. And so we come on to the solution. Paul Scully MP was the minister who introduced the bill to Parliament, and he said that it would support landlords and tenants who cannot otherwise agree in resolving disputes relating to rent owed, will protect rent debts built up by businesses required to close, and will establish a binding arbitration process that aims to find a proportionate solution and essentially help businesses to recover from the pandemic. The bill itself, at the heart of this webinar, is not a long document. It's only 30 pages or so, but I'm going to break the analysis down into 5 parts, starting first with some key definitions, then looking at the mechanics of the arbitration process, dealing then with the moratorium, which is principally in the schedules to the bill, what will be the Act, a brief consideration of the future, and then by way of overview, there's quite a helpful little diagram that's in the code, and a reminder of some of the important dates that we've looked at this morning. The concept of the protected rent debt is defined very early on in the bill in clause 3, a debt under a business tenancy consisting of unpaid protected rent. What is protected rent? Well, rent due is protected rent if A, the tenancy was adversely affected by coronavirus, also defined, and the rent is attributable to a period of occupation by the tenant for a period within the protected period applying to the tenancy. Adversely affected by coronavirus means that the whole or part of the business or whole or part of the premises was subject to a closure requirement. That is, as a result of the various coronavirus regulations during the period March 2020 to July 21. The protected period began on the 21st of March 2020, and it ends with the earlier of the last day on which the whole or the part of the business or the premises was subject to a closure requirement or a specific coronavirus restriction, or the 18th of July 2021. And a specific coronavirus restriction, in substance, is a restriction which falls short of a closure requirement. The matter of relief from payment. This is also an important concept within the bill, defined at clause 6, where it is said that reference to the matter of relief from payment of a protected rent debt are to all issues relating to the questions of whether there is a protected rent debt, and if so, whether the tenant should be given relief from payment of that debt and what relief. And in relation to a protected rent debt, relief from payment means writing off whole or part of the debt, giving some time to pay, or reducing any interest otherwise payable. So there's a menu from which the arbitrator can pick and choose. How does the arbitration work? Well, first of all, there has to be a reference. And when the landlord and tenant are not in agreement as to the resolution of the matter of relief from payment or a protected debt, then one of them may make a reference to arbitration within the specified period of 6 months for an enactment of the bill. But before doing that, the other party, the non-referring party, has to be notified and may make a response within 14 days. A reference itself must include a formal proposal for resolving the matter of relief, and it is to be supported by evidence. And the Code of Practice sets out that the proposal and documentation should be in line with the behaviours, principles, documentation and affordability criteria set out within the Code. So it's not an application made entirely in a vacuum. Now, on receiving a reference, in some circumstances, the arbitrator is bound to make an award to dismiss the reference. The obvious instances given in this slide are that an agreement has already been reached already, that the tenancy is not a business tenancy under the 1954 Act, or in fact, there is no protected rent debt. But it's also really important to note that an award dismissing the reference must be made if the tenant's business is not viable and would not be viable even if the tenant were given relief from payment of any kind. And it's only if the business is viable or would, in the event of relief, be viable, that the arbitrator must resolve the matter of relief by considering what relief, if any, should be given. And again, I've included here a quote from the Code of Practice, paragraph 57, that when referring to viability, parties should consider whether ring-fence debt aside, the business has or will in the foreseeable future have the means and ability to meet its obligations and to continue trading. In considering what award to make, The arbitrator has to have regard to any final proposals made by the parties, and also crucially, the principles set out right in the middle of the bill at clause 15, which I'll deal with in a moment, but it's worth just noting first that if time to pay is given, it's not entirely open-ended. The payment date has to be within 24 months of the day on which the award is made. Generally, an award itself must be made as soon as reasonably practicable after proposals are submitted, or if there is an oral hearing, which can be requested by one or both parties within 14 days of that. So we come to clause 15. What are the principles? Well, any award should be aimed at preserving or restoring and preserving the viability of the business of the tenant. That runs through both the bill and the code itself, but so far as that is consistent with preserving the landlord's solvency. It's not about helping one business to survive, but putting another into liquidation. Second, the tenant should, as far as is consistent with the above, be required to meet its obligations as regards the payment of protected rent in full and without delay. There's also some guidance in clause 16 as to how the viability of the tenant's business and the solvency of the landlord are to be assessed. So, for instance, there's an express requirement to disregard the possibility that either party may borrow or restructure its business. A topic close to the heart of many lawyers will be the costs, fees and expenses of the entire process. Perhaps unsurprisingly, arbitration fees are generally split 50-50 when an award is made, although there is a discretion to depart from that general principle. But crucially, however, the parties themselves must meet their own legal costs. And in particular, though a well-drawn lease will often have a provision that a landlord may recover his or her costs, usually on the indemnity basis, that will simply not apply in a situation where there is a referral to arbitration under the bill, what will be the Act. It's simply not recoverable. That's clause 19. Now, the code of practice, which I've been referring to, as I said, was published on the same day as the bill, and it gives an insight into how the bill and the arbitration process are supposed to operate in practice. Again, it's not a terribly long document, but particularly helpful parts are actually found at the end in Annex A, which sets out the dates of the various closures and lockdowns and how they impacted on various types of businesses, for those who need a refresher course on the various regulations. Annex B, which is said to be a non-exhaustive list of documents that the parties can use to prove their own financial situation, both within negotiation and arbitration, overdue invoices, tax demands, money judgments, and solvency of a major customer. It's a long list, but it's helpful to refer to. And finally, Annex C, which I've included later in this presentation, and contains an overview of the whole process. And an indication of what the code is supposed to do is set out in the ministerial forward to that. The updated Commercial Rents Code of Practice aligns with the legislation, sets out what the process is supposed to look like, kind of evidence that will be considered, and the key principles. It provides guidance on how parties should approach negotiation, with the intention that where possible, they should resolve disputes before the bill comes into force. The moratorium. The relevant parts are found in Schedule 2, Schedule 3, and clauses 24 to 25 of the bill. Schedule 2 deals with a variety of matters, perhaps most importantly, debt claims. There is a bar on making a debt claim during the moratorium period, which is defined in clause 23.2 to be the period for references to arbitration, i.e. 6 months. or where there has in fact been a reference, the day on which the arbitration concludes. And where claims were started on or after the 10th of November 2021, it's possible to stay the proceedings, and an unpaid money judgment cannot be enforced until the end of the moratorium period. So the Act does have retrospective effect in that sense. Crier and forfeiture, again, may not be used during the moratorium period, which obviously has the same definition under 23(2). There's simply no ability to exercise a right of re-entry or forfeiture. And there are also some other provisions, a suspension of the usual right of the creditor to appropriate rent as he or she wishes, and also a bar on using the deposit, any tenancy deposit, to pay the unpaid rent. Schedule 3 deals with insolvency. There's a bar on presenting a winding up petition in respect of a protected rent debt during the moratorium period, again 6 months, or where there is a reference, the day on which the arbitration concludes. In respect of bankruptcy, there's a bar on presenting a petition where the statutory demand relating to a protected rent debt was served during the relevant period, and that has a retrospective element. It goes back to the 10th of November 21 and ends on the day mentioned in clause 23(2)(b), the end of the moratorium period. So it's a little bit more extended than winding up. And also notably, there's a provision that if a bankruptcy order was made after the 10th of November 21, it will be deemed to be void. Clauses 24 and 25 deal firstly with CVAs, IVAs. There's a restriction there in circumstances where an arbitrator has been appointed. And clause 25, perhaps not surprisingly, contains a general prohibition of, in respect of arbitration outside the scope of the bill in respect of a protected rent debt during the moratorium period. So what about the future? Well, the bill is future-proofed in two senses. The first is that, though under clause 9.2, the reference has to be made within 6 months of the bill becoming law, becoming an act, it is possible by regulation under clause 9.3 for the Secretary of State to extend that period. The second element to this is clause 27, that provides that by regulation, the Secretary of State may provide for the Act to apply again in relation to rent debts under business tenancies affected by closure requirements. This overview of the process, as I said, is found in Annex C of the Code. It looks more complicated than it is, and simply walks you through the different stages: a letter of notification, pre-action negotiation, request for arbitration, acceptance of the application by the arbitrator, offers a method of resolution, the hearing if there is one, and the decision. And by way of summary, I thought I would go back through the key dates. There are quite a few of them, but first of all, the bill is expected to become law on the 25th of March. The relevant period for determining if the tenancy was adversely affected by coronavirus is the 21st of March to the 18th of July. That's March 20 to July 21. The protected period is March 20 to July 21, but it can be earlier if the last day on which the business or premises were subject to a closure requirement or coronavirus restriction. If that's earlier than the 18th of July, then it will be on the earlier date. And the period for making a reference, well, that's 6 months from the bill becoming law, although, as I said, by regulation, it's possible that that will be extended. 24 months is the maximum time which can be given to pay if an award is made. And the moratorium period is 6 months, or the day on which an arbitration concludes. The 10th of November 21 is the critical date in respect of which the Act might have retrospective effect in relation to court proceedings and bankruptcy petitions and orders and so on. So some conclusions on all that. The Act, the bill, is radical in the sense that it does, in some circumstances, give the arbitrator the ability simply to relieve the tenant of the obligation to pay rent. But it is limited in scope in terms of both the criteria to be applied and also the period of time under consideration. There is also a need to act swiftly. 6 months to make a reference from the bill becoming law is not a very long time. So it's almost a case of blink and you miss it. There does not appear to be an ability in exceptional circumstances to extend that period into the future, save the general power under 9.3 of the Secretary of State by regulation. And of course, finally, for some tenants, it will be too late. Individual tenants who might have been made bankrupt, or those against whom judgment has been entered in the County Court or High Court and judgment enforced. So it is in some sense, a remedial measure. Thank you very much for listening. If there are any questions, I will do my best to answer them. One of the glorious things about talking about a bill is there's no case law on it, so we're all speculating a bit. But like I said, I will do my best. I've included my contact details there, so if anyone has any questions which they don't want to ask publicly or which occurs them later, then they can ask away. Now I'll just I can see a number of questions have come up there. That's the first one. The first one, that's jolly easy. Will the slides be circulated afterwards? I think we can probably arrange that. Can compulsory arbitration apply to non-financial disputes, such as a dispute about a break notice or about applied surrender? I don't believe so. An excellent question there from John Clifford. Are there likely to be enough arbitrators, or can we expect the same sort of delays the courts are suffering? Difficult to say at this stage. There are going to be regulations providing for the appointment of arbitrators. My guess is that actually, if the fees are right, that there will be a queue of people willing to arbitrate in these matters, and so actually it might relieve pressure on the courts. But that is really a guess. Is there going to be a panel of arbitrators? Yes, there's a provision essentially in the Act, in the bill, for arbitrators to apply to be appointed. There's also going to be regulations which obviously haven't been made yet. Will there be a recording? Yes, this is being recorded. It will go on the St Philip's website and also I think on YouTube. Next question. Should landlords considering issuing a claim for unpaid rent before the bill becomes law? No, because of Schedule 2, it's inevitable that the proceedings will be stayed. If they're not stayed and judgment is entered, enforcement will be suspended. So if you've missed the boat by the 10th of November 21, it's really too late. If you've issued proceedings pre-10th of November 21, will this affect the proceedings? No, I don't think so. I think you're okay. And somebody anonymously asks, what sort of considerations will an arbitrator keep in mind when making its decision? Well, it's really those principles set out in clause 15 of the bill, the viability of the tenant's business set against the need to preserve the solvency of the landlord, coupled with the requirement that a debt should be paid really as soon as reasonably practicable. So it will involve what could be quite a complicated financial analysis and comparison of the financial positions of the various of the parties, usually of the two parties. Would service charges be captured by this bill, please? Yes, yes, they would. Rent is defined to include amounts due, both rent and service charges. Does the landlord have an obligation to apply within the 6 months, or is the onus on the tenant to do so? From Kate Burton, that's a very good question. There's no onus on either party, and it may be the landlord or it may be the tenant. One suspects that it will be the tenants in greater number who make this sort of application, but it can be either party. The important point is that when the reference is made, proposals have to be attached to that reference. Can multiple leases be dealt with in one arbitration? That's a good question. I don't know the answer to it, and I would have happily looked into it and emailed a response. But the question the question is made anonymously. The perils of not showing your name. Any right of appeal other than on a point of law. So the Arbitration Act, in substance, will apply with some variations. That's applied or set out in the bill. If neither party applies, can the landlord just sue for the arrears after the 6-month period has passed? Yes, absolutely. And then something similar from Catherine Baker. If the 6-month period has run out, then just issue for debt and enforce. Correct. In theory, then the landlord cannot take any action for 6 months and then issue proceedings if the tenant has taken no action. Yes, they could. That's correct. What's the likely cost of the arbitration going to be? Well, what's the cost of litigation? It depends very much, I think, on the nature of the case. Are we dealing with two very large organisations and rent arrears perhaps running into the hundreds of thousands of pounds, or something very much smaller? What sort of lawyers are involved? Are we talking about high street firms or international law firms? It depends on the circumstances. So just as litigation can vary enormously, so I think can the costs of an arbitration under what will be the Act. But the crucial thing, of course, is that win or lose, the landlord isn't able to recover his or her costs under an indemnity clause in the lease. So that is a whistle-stop tour through 17 questions. Oh, there's an 18th there. There's another one. What if there are arrears before March 2020 and after July 21? Can the tenant make a request or need to reduce the arrears before making a request, please? Well, the arrears that have accrued before or after that date are simply outside the scope of the Act, so the arbitrator wouldn't be able to make any sort of decision in respect of them, and they would be open to the usual processes of court action or winding up petitions, bankruptcies, and so on. So there we have it. It's 10 o'clock. I've taken half an hour of everyone's time. I've done my best to go through those 18 questions or so. If anyone does have anything else or any thoughts or questions, then please do send me an email. But look, it's been a great pleasure to talk to everyone today about the bill. Thank you for listening, and I hope you all have a great day.